by law, because we have our COVID protocols, we are required, all trials are, all defendants has a right to have hearings and trials public. So in essence, since we have the COVID protocol, when people can't come into the courtroom, we have to broadcast it on YouTube. So it is open to the public by being broadcasted on YouTube. And that's because of the law that we have in the state of Texas. Now, our next case is cause number 329034. And that case is styled the state of Texas versus Chantel Nicole Breed. Ms. Breed, is that your full name?
Yes, sir.
Ms. Breed, would you please raise your right hand? Ms. Breed, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Breed, you may put your hand down. How are you doing, Ms. Breed?
Good.
That's good. Ms. Breed, I have before me an information, a document that has been filed by the state of Texas or the District Attorney's Office of Jefferson County. And this information alleges that on or about October 23rd of 2020, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance, penalty group 2A. Ms. Breed, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Breed, how did you plead? Guilty, not guilty, or no contest?
Contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Are you pleading no contest because you do not wish to fight the charges or contest the charges?
Yes, sir.
I'm gonna need her affidavit. Ms. Breed, I also have another document before me. This document is titled Misdemeanor Plea Admonishments. On page 2 of this document, there are a set of initials SB on a line next to a box that is checked nolo contendere, which means no contest. Ms. Breed, did you place your initials on this document?
Yes, sir.
On the next page of the same document, there is a signature above the line that is titled Defendant. Ms. Breed, did you sign this document?
Yes, sir.
I have another document before me that is titled Trial Court Certification of Defendant's Right of Appeal. At the bottom of this document, above the line that is titled Defendant, there's a signature on that line. Did you also sign this document?
Yes, sir.
Now, Ms. Breed, at the top of this same document, there are two boxes that are checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Now, Ms. Breed, did you sign a document out there on paper that is titled Discovery Certification?
I have it right here. I'm going to sign it now.
Okay. Now, Ms. Breed, that document that you just signed, and as well as the other documents that I have just mentioned, did your attorney go over those documents with you?
Yes, sir.
And did you read and understand everything in those documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Breed, are you a U.S. citizen?
Yes, sir.
State, I have before me State's Exhibits number 1, the misdemeanor plea admonishment. State, if you like to offer State's Exhibit number 2, also the probable cause affidavit.
Yes, Your Honor.
Any objections, Mr. Vasquez?
No objections, Your Honor.
No objections. State's Exhibits 1 and 2 are admitted. Mr. Vasquez, you have advised and counseled Ms. Breed. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Breed, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Ms. Breed, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, the agreement is for 30 days in the Jefferson County Jail.
Okay, Ms. Breed, the state is offering that you serve 30 days in the Jefferson County Jail. Now, you will be given credit for any time that you have already been served or any time that you are entitled to get by law. The court cost in this case is $327. Ms. Breed, will you be able to pay the $327?
Yes, sir.
You will? Okay, now, Ms. Breed, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay. Ms. Breed, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Breed, this will conclude your case. Please follow the bailiff and you have a blessed day.
You too. Thank you.
Okay, ladies and gentlemen, County Court at Law number 2 is a misdemeanor court. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type cases. They are handled in the district court, like Judge Stevens. Now, with the felony cases, those cases are classified in the 5 categories. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, or state jail felony. Now, the range of punishment, if a person is convicted for a capital murder, is life or death. If a person is convicted for a first-degree felony, the range of punishment is 5 to 99 years to life. If they're convicted and a fine up to $10,000. If they are convicted of a second-degree felony, the range of punishment is 2 to 20 years, a fine up to $10,000. If they're convicted of a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, fine up to $10,000. Or if they're convicted of a state jail felony, the range of punishment is 6 months to 2 years in the state jail, fine up to $10,000. Now, this court do not handle felony cases. So that just simply means that we only handle misdemeanor cases. Misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they are not as serious as a felony offense. Misdemeanor cases are classified as a Class A, a Class B, or Class C misdemeanors. Your Class C misdemeanors are normally handled in the municipal court. We call it the city court, or the JP court, the Justice of the Peace Court. And those cases, the range of punishment is fine only. They cannot be given jail time. They only can be given a fine. A case, for example, that would be classified as a Class C misdemeanor is speeding, or not wearing a seatbelt, or not having insurance. Those are cases that are classified as a Class C misdemeanor. Now, we handle Class C misdemeanors when those cases are appealed up from the JP court or the city court, and we handle Class A and B misdemeanors. A Class A misdemeanor is our highest misdemeanor. The range of punishment for a Class A misdemeanor is 0 days in the county jail or 365 days or anywhere in between, or a fine from $0 to $4,000 or anywhere in between. Or if you're convicted of a Class B misdemeanor, the range of punishment is 0 days to 180 days in the county jail, or a fine from $0 up to $2,000. Now, a person could be given, if they're qualified, it could be given probation. Probation just basically means they're not serving time in jail, they're out in the public. There are 2 types of probation. One is called straight probation, which does result in a conviction in your record. And the other type is called deferred adjudication, which does not result in a conviction in your record. Now, when a person has an option to either plead not guilty, guilty, or no contest. If they plead not guilty, they're telling the court that they did not commit the offense that they've been charged with. If they plead guilty, they're telling the court they committed the offense that they've been charged with. Or if they plead no contest, then they're telling the court that they will not be fighting, or they will not be contesting the charges. So our next case that we have, Mr. Vasquez, are you ready?
Yes, Your Honor.
Okay, and Who's your next client?
Judge, this is Mr. Hingston, Travis
Hingston?
Hingston.
Okay. Hingston. Hingston. Okay, we have two applications. One being dismissed. Okay. It's Hingston. The prosecutor stepped out a minute, just so we'll be ready when the prosecutor come back. Now, ladies and gentlemen, every courtroom that you go into or basically have the same layout. Now, the area that you're sitting in, we call that the peanut gallery. Now, it doesn't mean you can eat peanuts in here. It's not the Texas Roadhouse, okay? Now, that wall that's between you and the court, we call that the bar. And only individuals who are allowed to come past there are lawyers or individuals who have the permission of the court to come past there. That's when lawyers, they have to take a test when they finish law school. The test is called a bar exam. And when you pass the bar, then you're allowed to come past that area. Now, also that area that back over here, we call that the jury box. That's where the jurors sit. And in this court, in misdemeanor court, you have 6 jurors. In felony court, they have 12 jurors, okay? It's a little different. This chair right here is called the witness stand. And the witness, what they do, they can testify. They can testify either for you or against you. Your lawyer can ask some questions. We either call it direct examination or cross-examination. Now, the area where I'm sitting is called the bench. This is where the judge sits. We call that the bench. Those 2 tables that's out there, we call those counsel's tables. The prosecution sit on one side, the prosecution is the state, and the defense, the defendant and the defense attorney sits on the other side. We call that counsel table, okay? And so as you observe, there's more than one person in here. I'm not the only person here. We have our court reporter. The court reporter is taking out everything that is being said, okay? And we have our court clerk who's giving us the paperwork, and we have our court coordinator who is resetting cases. And so in essence, also the gentleman in the uniform is the bailiff. We have our bailiff here. And we also have 2 defense attorneys here, Mr. Mitchell and Ms. Provo. And Mr. Mitchell is here also with his client. So at this time, we're going to go into our next case. Court is back in session in cause number 331-294, excuse me, cause number 331-296 and cause number 331-298. Both cases are styled the state of Texas versus Travis Centel Hingston. Mr. Hingston, is that your full name?
Yes, sir.
Mr. Hingston, would you please raise your right hand? Mr. Hingston, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Hingston, you may put your hand down. How are you doing, Mr. Hingston?
All right, and you?
I'm doing fine. Thanks for asking. Mr. Hingston, in cause number 331-296, I have before me an information that has been filed by the district attorney's office. This information alleges that on or about November 2nd of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Mr. Hingston, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Hingston, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Hingston, I have before me another document. This document is titled Misdemeanor Plea Admonishment. And on page, it is also labeled as State's Exhibit Number 1. On page 2 of this document, there are a set of initials TH on a line next to a box that's checked no contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there is a signature above the line that is titled Defendant. Did you sign this document?
Yes, sir.
I have another document before me. This document is titled Trial Court Certification of Defendant's Right of Appeal. At the bottom of this document, there is a signature above the line that is titled Defendant. Mr. Hingston, did you sign this document?
Yes, sir.
At the top of this document, there are 2 boxes that are checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you are waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Now, Mr. Hingston, are you a U.S. citizen?
Yes, sir.
Mr. Hingston, well, state,
Yes, Your Honor.
well, Mr. Hingston, prior to signing and initialing these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State. I have before me State's Exhibits Number 1, the misdemeanor plea admonishment. State, you like to offer State's Exhibit Number 1 and State's Exhibit Number 2, the probable cause affidavit.
Yes, Your Honor.
Mr. Vasquez, do you have any objections?
No objections, Your Honor.
No objections. State's Exhibits 1 and 2 are admitted. Mr. Vasquez, you have represented and you have advised Mr. Hingston. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Hingston, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Hingston, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
Your Honor, in case number 331296, the agreement is for Mr. Hingston the agreement is 30 days time served for the court costs to be taxed and retired.
Okay.
In addition, the state will dismiss case number 331298. So
Mr.
that
Hinks,
Mr. Hingston can go serve his time in the penitentiary.
okay. Mr. Hingston, the state is offering that you serve 30 days in the Jefferson County Jail. However, you will not have to serve any more time in the Jefferson County Jail because you've already served 30 days in Jefferson County Jail. Therefore, you will be given credit for time served. The court cost in this case is $327, but you will not have to pay the $327 because the time that you spent in jail has already paid it off. And the state will be dismissing cause number 331298. Mr. Hingston, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Hingston, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Hingston, this will conclude your case. Please follow the bailiff and you have a blessed day.
You too.
Thank you. We're gonna do Mitchell next. Hey. You want to do Mitchell next?
Yes, Your Honor.
Yeah, we're gonna do one case. It's on.
No way.
Oh, it's on the note. Oh,
Yeah.
okay.
Man of the law.
Okay. No, how did? Now. Okay. You don't have? Oh, she doesn't have it ready yet, so just, yeah. Okay, Mr. Vasquez, we'll do your next client. I just got out of. Yeah.
Excuse me, Your Honor. This is Robert Fleury, Your Honor.
Lori, okay.
Your Honor, this is the last plea that we were able to work out.
Yeah, okay. Okay. The court is in session in cause number 330760. Case is styled the state of Texas versus Robert Allen Fleury. Mr. Fleury, is that your full name?
Yes, sir.
Mr. Fleury, would you please raise your right hand? Mr. Fleury, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Mr. Fleury, you may put your hand down. How are you doing, Mr. Fleury?
I'm doing all right.
That's good. Mr. Fleury, I have before me a document that is titled Information that has been filed by the Jefferson County District Attorney's Office. This information alleges that on or about August 31st of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance, penalty group 2A. Mr. Fleury, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Fleury, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, Mr. Fleury, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Fleury, I also have before me a document that is titled Misdemeanor Plea Admonishment. On page 2 of this document, there are a set of initials, R or F, on a line next to a box that's checked nolo contendere, which means no contest. Mr. Fleury, did you put your initials on this document?
Yes, sir.
Page 3 of the same document, there is a signature above the line that is titled Defendant. Mr. Fleury, did you sign this document?
Yes, sir.
Now, Mr. Fleury, I have another document before me. This document is titled Trial Court Certification of Defendant's Right of Appeal. There is a signature above the line that is titled Defendant at the bottom of this document. Mr. Fleury, did you also sign this document?
Yes, sir.
Mr. Fleury, there are two boxes that are checked at the top of the same document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. The second box that's checked states that you're waiving, which means you're giving up your right to an appeal. Did you understand that?
Yes, sir.
Mr. Fleury, did you sign a document out there that is titled Discovery Certification?
Yes, sir.
Now, Mr. Fleury, prior to signing and initialing those documents, did your attorney go over those documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Fleury, are you a U.S. citizen?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, you like to offer State's Exhibit number 1 and State's Exhibit number 2, the probable cause affidavit.
Yes, Your Honor.
Any objections, Mr. Vasquez?
No objections, Your Honor.
No objections. State's Exhibits number 1 and 2 are admitted. Mr. Vasquez, you have advised and counseled Mr. Fleury. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Fleury, your attorney, Mr. Vasquez, Tell him what to sit. Yeah, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Fleury, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, the agreement is for 30 days in the Jefferson County Jail.
Mr. Fleury. Hey. Yeah, they can sit in those side chairs. Okay, Mr. Fleury, the state is offering that you serve 30 days in the Jefferson County Jail. You will be given credit, you will be given credit for any time that you are entitled to get by law. The court cost in this case, Mr. Fleury, is $327. Mr. Fleury, will you be able to pay the $327?
No, sir.
Okay, now, Mr. Fleury, I have before me an affidavit of indigence that was, that has your name on it. It appeared to be, it was signed by a magistrate on February 9th of 2022, which was about 2 weeks ago.
Yes,
Now,
sir.
Mr. Fleury, the judge who signed the affidavit acknowledged that you currently met the eligibility requirements for the appointment of a court-appointed attorney. And what that basically means is that you were indigent. And based on that finding of indigency, this court will also find that you're indigent. And pursuant to Article 42.15 of the Texas Code of Criminal Procedure, your court costs will be waived. That simply means that you will not have to pay it. Now, Mr. Fleury, do you understand the state's offer and the court's findings?
Yes, sir.
And do you think that is fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Hey, Mr. Fleury, I'll follow the plea bargain agreement that you have entered into with the state. You sentenced to 30 days. You'll be given credit for any time that you're entitled to get by law. The court costs in this case will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure because the court is finding that you are indigent. Mr. Fleury, this will conclude your case. You can follow the bailiff and you have a blessed day.
You too, sir.
Thank you. And Mr. Vasquez, this will conclude your case as well. Is that correct?
That's correct, Your Honor.
Yes, Your Honor.
He said these are the only ones that fled. They're gonna rescind. Well, okay, just hold on, Mr. Vasquez. We're gonna do we're gonna do a plea. Hold on a minute.
Yes, sir.
Yeah, Mr. Mitchell. Mr. Mitchell. Okay, there she got Mr. Court is in session in cause number 328-610. The case is styled the state of Texas versus Amanda Nicole Now. Ms. Now, is that your full name?
Yes, sir.
How are you doing, Ms. Now?
Good, how are you?
I'm doing fine. Ms. Now, you're here represented by your attorney, Mr. Brennan Mitchell. Mr. Mitchell, how you doing?
Doing fantastic, Judge. How you doing?
I'm doing fine. Thanks for asking. Ms. Now, would you please raise your right hand? Ms. Now, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Now, you may put your hand down. Ms. Now, I have before me a document that is titled Information. This document was filed by the Jefferson County District Attorney's Office. This document alleges that on or about December 5th of 2020, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of interfering with public duties. Ms. Now, do you understand what you have been charged with?
Yes, sir.
Is the battery gone? Let me do another one. And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Now, I have another document before me. This document is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Ms. Now, there are a set of initials on the line that's checked null or contingent, which means no contest. Did you place your initials on this document? You have to speak up.
Say yes or no.
Yes, she's taking a record.
Yes, you did.
On page 3 of this same document, there's a signature above the line that is titled Defended. Is that your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
Is this your signature above the line that is titled Defendant?
Yes, sir.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you are giving up your right to an appeal. Do you understand that?
Yes, sir.
Yes, now, I also have a document before me that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature above the line that is titled Defendant?
Yes, sir.
Ms. Now, prior to signing and initialing all of these documents that I've just mentioned, did your attorney, Mr. Mitchell, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Now, are you a U.S. citizen?
Yes, sir.
State, I have before me States Exhibits 1 and 2. State, you like to offer States 1 and 2?
Yes, Your Honor.
Any objections?
No objection, Judge.
No objection. States Exhibits 1 and 2 are admitted. Mr. Mitchell, you have advised and counseled Ms. Now. Is there any evidence that she is currently mentally incompetent to stand trial?
None whatsoever, Judge.
Ms. Now, your attorney, Mr. Mitchell, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Now, I would accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Did we, you offer States 1 and 2, right?
Yes, Your Honor.
Mr. Ham, do we have a plea bargain agreement in
We
Ms.
do, Your
Brown's
Honor.
case? What is that agreement?
Your Honor, the agreement in this case is for 1 year of deferred probation and 40 hours of community service.
I'm looking at a straight probation on here.
Should be deferred, Judge.
I think what happened was somebody filled out 90/1.
I'm looking, but it's marked deferred.
No,
No.
it's marked straight. Somebody put a star. Y'all can look at
Then
it.
that's our mistake, Your
Okay.
Honor. We need to refix, we need to fix that.
Okay. No, see, yeah. You can't get jail time on a deferred. It has to
Sorry,
be
I
on.
don't know why this is.
So she's gonna have to redo the paperwork.
I don't know how that.
And that's the,
I'm glad the judge got it.
Yes.
Deferred, 1 year, no fine, 40 hours of community service.
Yeah, she's gonna have to do the paper, send it, you send it back,
Send it back to myself.
because we have to close it so you can get in it. Yeah, just go down and, just go ahead on and close it so she could get in and make that necessary change. Just gonna take a few minutes to do the paperwork. It's you
So
close.
Joy, I don't know, does that need to come back to me?
No,
I should be able to.
no, it was already open. So you just give it back to me. Yeah,
Yes, sir.
yeah. Yeah, she got it.
Apologize for that, Judge.
No, that's all right.
That's our fault.
Okay.
You gotta take off that 90.
It's off there.
No, okay.
Let me take a look.
I didn't just erase it.
Are
I
you
closed
still
it
in it?
without saving it.
Are you still in it?
Yeah.
Okay.
Well, we have paperwork in Orange County.
Yeah, he got the 90 on here. You gotta take that off.
We'll get this, so I'm
Yeah.
gonna fix it, I'm gonna save it, and then I'm gonna close it.
Save.
Save it.
Okay,
That should
Yeah.
take care of it.
that's good. And in the meantime, y'all can take a seat. I can just inform our class what's going on, because I don't think I told them.
Hey,
What-
I don't know, computer science isn't part of law school.
Now, ladies and gentlemen, my name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. What you have been witnessing is what we call a plea bargain. All right. A defendant has a right to enter one of three types of pleas. They can enter a plea of guilty. If they enter a plea of guilty, they're telling the court they committed the offense that they've been charged with. Or they can enter a plea of not guilty. If they enter a plea of not guilty, they're telling the court that they did not commit the offense that they've been charged with. Or they can enter a plea of no contest. No contest means that you are not fighting or you are not contesting the charges, the charges that has been brought up against you. And so now individuals have rights. They have a right to have a jury trial. You have a right to have an attorney. You have a right to have a jury trial. You have a right to have witnesses come to court. You have a right to have to see the state's evidence, the evidence that they have against you. Now, in reference to the right to have a jury trial, and just like all of the rights that I just mentioned, you have a right to waive or give up your right. And so if you waive your right to have a jury trial, then you can come before the court on a plea bargain. What a plea bargain is, it's an agreement that has been reached between the state and the defendant to settle their case. And that's what you are witnessing. Well, a person said, well, Judge, I'm entering a plea of guilty or no contest, and me and the state, we have reached a plea bargain agreement, and we want to bring this agreement before you to see if you will accept the agreement, or the judge can reject the agreement. And so that's basically what you're witnessing. Now, in County Court at Law Number 2, County Court is different from District Court. District Court is like in Judge Stevens' court, is a felony court. Criminal cases are divided into felonies or misdemeanors. Felony cases are your most serious type cases. For example, you can have a capital murder, first-degree felony, second-degree felony, third-degree felony, or state jail felony. First-degree felony, if a person is convicted, capital murder, if they are convicted, you can either get life or death as your punishment. For first-degree felony, the range of punishment is anywhere from 5 to 99 years to life, or fine up to $10,000. For a second-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, fine up to $10,000. For third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, fine up to $10,000. And for a state jail felony, the range of punishment is 6 months to 2 years in the state jail, fine up to $10,000. Now, misdemeanor, the county court does not have jurisdiction, or we do not have authority to handle felony cases. And so what that means is we only handle misdemeanor cases. Now, misdemeanors are divided into Class A, Class B, and Class C misdemeanors. Your Class C misdemeanors are handled in the city court. Person get a traffic ticket, that's a Class C misdemeanor. Person not wearing a seatbelt, that's a Class C misdemeanor. Person doesn't have insurance, that's a Class C misdemeanor. And so with your Class C misdemeanors, they're handled in city court and JP court, and you cannot get jail time. You only can get a fine only for a Class C misdemeanor. Now, Class C misdemeanors come up to this court when they are appealed. For example, person found guilty in city court or JP court, they want to appeal that case. It comes up to a higher court, which is this court, and we handle those appeals. Now, the range of punishment does not change. It's still fine only. We can't give them jail time. Now, we do handle Class A and B misdemeanors. Class A misdemeanors, your highest misdemeanor, the range of punishment is anywhere from 0 days to 365 days in the county jail or anywhere in between, a fine from $0 to $4,000 or anywhere in between. Or you can be given both such fine and confinement. For a Class B misdemeanor, range of punishment is 0 days to 180 days, which is 6 months in the county jail. A fine from $0 to $2,000, or you could be given both such fine and confinement. Now, you may qualify for probation. Probation basically means is that you will not be going to jail. You'll be serving out your punishment in society. And you have certain conditions, certain things that you have to do while you're on probation. All right? There are 2 types of probation. One type is called straight probation. The other type is called deferred probation. And if you just witnessed, in this case, the agreement was deferred probation, but straight probation was on the paperwork. What that basically means is this: the difference between straight probation and regular probation: straight probation results in a conviction on your record. Deferred probation does not result in a conviction on your record. And if you successfully complete that deferred probation, the case is dismissed, and you may qualify for a non-disclosure, which means we cannot disclose that fact to the general public. Okay? So that's why we had to stop, and we wanted to make sure we got our paperwork correct, and we got it correct. And so now we're going to get ready to go forward, and we're going to start off with the punishment phase of this offense. And as we pick up, first of all, we have Ms. Amanda Now. Ms. Now was sworn in. Ms. Now entered a plea of no contest. Ms. Now also acknowledged that her signatures and initials was on State's Exhibit Number 1, the misdemeanor plea admonishment. She acknowledged that her signature was on the trial court certification of defendant's right of appeal, and she acknowledged that she understood the boxes that was checked. The first box that was checked states that this is a plea bargain case and that she had no right of appeal. The second box that was checked states that she was waiving or giving up her right to an appeal. And she also acknowledged that her signature was on the discovery certification. The court accepted her plea of no contest. The court found that she was mentally competent to stand trial. The court also found that her pleas and waivers were freely and voluntarily given. And the court also found that there is sufficient evidence to find Ms. Now guilty beyond a reasonable doubt. State, we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, the agreement is for 1 year of deferred probation,
Okay,
during which Ms. Now will have to complete 40 hours of community service.
okay,
And this probation is to run concurrently with the probation in case number 21-36560, which she received in felony court.
okay. Ms. Now, the state is offering that you serve 1 year deferred adjudicated probation. During this 1 year probationary period, you will not be required to pay a fine. However, you will be required to pay court costs of $357. You will also be required to pay a probation fee of $60 each month, a year analysis fee of $15 each month. You also, now this will come to a total each month of $110. Would you be able to pay the $110 each month?
Yes, sir.
You will also be required to pay perform 40 hours of community service. This case will run concurrent with cause number 21-36560. And you also adhere to the other standard terms and conditions of your probation. Ms. Now, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Now, in this case will also run concurrent with cause number 21-36560. Now, Ms. Now, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Ms. Nile, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Nile, you're gonna stand on it. Now, Ms. Nile, if you, let me back up. Now, Ms. Nile, the court is gonna defer a finding of guilt, place you on probation for 1 year with the conditions that the court had just announced. And Ms. Nile, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Ms. Nile, you're gonna stand on the X next to your attorney. You're gonna follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Thank you.
Thank you.
And let me add something, Ms. Nile. Give me that, the paperwork. Now, Ms. Nile, if you are already currently on probation, that $60 probation fee, you only have to pay that once. So instead of you being required to pay $110 for this probation, you probably have to pay $50 plus the $60. They're gonna take that off because you're already on probation.
And we're not there yet, Judge. We're about to head down.
Okay,
Stevens Court.
But that's, okay, that's what's gonna happen. That's what'll happen. All right.
Appreciate it.
Yeah.
Your Honor, we were just trying to give the students an idea of how not to practice law.